Well, good evening, ladies and gentlemen, everybody out there in internet land, boys and girls, all members of Fedora Nation. And for those of you that aren't members of Fedora Nation, you ought to be. My name is Brian Trippett. I am your Front Porch Conservative. Welcome back to our latest session of Chattin on the Porch, a lively little discussion where we bring on guests and talk about things going on in the world. And boy, is there a lot going on in the world these days. One of the biggest things that's going to be happening is tomorrow morning, which is why I've asked a guest to come back to the Electronic Front Porch, and we get into a discussion about it and other things, all matters legal. So we're on YouTube, we're on Rumble, we are on Twitter, and if you haven't done it already, send out a message to your friends, send out a message to your brothers, your mothers, your lovers, your sisters, and your misters, and tell them to get in here because we have got quite the show this evening. Again, we're on YouTube, we're on Twitter, we're on Rumble, so thank you very much for stopping by. We'll let everybody get into their seats, and then we will get this party started. Well, it has been already an eventful 1 month and 1 week of the year 2024, and every day it seems like there's something big that's popping in the news, and tomorrow morning is going to be one of the biggest things popping in the news. In case you haven't heard about it, tomorrow morning the Supreme Court of the United States will take up Trump versus Anderson, the Colorado ballot access case. Basically, it is the decision now of the Colorado Supreme Court that says Donald Trump cannot be on the ballot for president in the state of Colorado on the grounds that he is in violation of the 14th Amendment. So, when considering all the situations that are involved with that, I thought it was time to reach out to somebody who has looked at this issue and can bring us some serious good perspective on it. To that, we bring back a returning guest. Daniel R. Street lives in Monroe, Louisiana with his family. He holds a bachelor's in arts and history and a Juris Doctorate from Louisiana State University. He practices civil law and has appeared before state and federal courts. A lifelong member of the NRA, he has appeared on such shows as American Thinker, America Out Loud, the Joseph Ford Cotto podcast, and Inside the Numbers with the People's Pundit, Rich Barris. He is the author of Fake News Exposed About Trump, Volumes 1, 2, and 3, and he is the author of Fake News Exposed, 25 of the Worst Media Lies About Conservatives, Guns, COVID, and Everything Else. Ladies and gentlemen, please welcome back to the Electronic Front Porch one of our favorite lawyers, Mr. Daniel R. Street. Daniel, how you doing tonight?
Doing great. Thanks for having me back.
Oh, glad to have you. Glad to have you. Oh man, it is a absolutely crazy time. And given your writing, given your everything else, I thought, man, you'd be a perfect person to talk about this with. So let's just dive right in. The Colorado ballot access case, maybe for those who aren't familiar with what the heck is going on tomorrow morning at the U.S. Supreme Court, what is this case all about? What is being claimed? What is the defense that former President Trump is putting up? And just set it up for us, and then I've got some follow-up questions for you.
Sure thing. And before I get to the answer, I wanted to tell you I need to take that introduction you did for me and copyright it and use it all the time. So that was great. I really appreciate that. The Colorado case. Real simply, what happened was about a year and a half ago or so, some commentators and some legal analysts, professors and whatnot came up with this theory that they could try to disqualify President Trump from office using Article 3 of the 14th Amendment to the United States Constitution. Now, let me back up just a little bit. Really, 150 years or more, 170 years, and explain what the 14th Amendment is and what the Article 3 is. The 14th Amendment was one of the 3 constitutional amendments passed in the wake of the Civil War in the United States. Civil War was brought to an end in 1865. The 14th Amendment was passed in 1868. Article 3 of the 14th Amendment basically provides, just to summarize, that...
Hold that thought. I'm going to do you a favor here. I'll make it easy on you. There you go.
There we go. Basically, it says that what it was intended to do was to prohibit former Confederates, former Confederate officers, Confederate soldiers, people who had fought in the Civil War for the Confederacy from coming back into federal office primarily in Congress, but also perhaps in the military and other federal offices. And so that's what Article 3 of the 14th Amendment was geared towards. Now, so these commentators that I was referencing, and the law professors and whatnot, brainstormed this and said, hey, we can try to disqualify President Trump using Article 3 of the 14th Amendment. That kind of started a groundswell mostly amongst never Trumpers and lefties. And they filed these challenges literally all over the country. The last survey I did of it, there were a handful of states I was not able to identify that a challenge had been filed in, but they got voters and filed election challenges trying to disqualify President Trump in state after state after state. One of those states, in the state of Colorado, the case got all the way to the Colorado Supreme Court. Colorado was the first case to rule that President Trump could be disqualified by Article 3 of the 14th Amendment. So to break down the actual argument that is being made is the people filing these challenges claim that President Trump, by virtue of the speech he gave on January 6, 2021, and by various different efforts that he made to challenge the results of the 2020 election, had engaged in insurrection within the meaning of Article 3 of the 14th Amendment, and was therefore barred, or could be barred, from being president again, or holding the office of president again. So that's what the fundamental claims are. It's actually considerably more complicated than that, but that's the gist of it. And the Colorado Supreme Court overruled the lower court in Colorado, which had ruled President Trump was not disqualified, and disqualified him from the ballot in the state of Colorado. Now, the Colorado Supreme Court suspended that and put in the order that it would be suspended if President Trump applied for writs to the United States Supreme Court, which he did. So it's not a bar. It won't go into effect unless and until the Supreme Court of the United States allows it to go into effect. So that's the basic claim being made against President Trump on that particular challenge.
Okay. I want to ask you something, because to me, when this is argued tomorrow morning before the U.S. Supreme Court, there are two things in my mind that the court has to do one way or the other. One of them is they have to determine, is the office of the President of the United States subject to the terms and conditions of Section 3 of the 14th Amendment? But the bigger question is this: did the actions that Donald Trump took on January 6th when he was giving his speech, and even you could argue prior leading up to it, do they constitute insurrection? Which gets me to my next question. For purposes of the federal government, is there a statutory definition in law that says insurrection is defined as this?
Yes. Okay. So insurrection was originally defined for the first time that I'm aware of in 1795 in the Militia Act of 1795, and then subsequently in the Insurrection Act of 1807. Okay. Insurrection has historically in federal law required a declaration by the President of the United States that there is some portion of the country that's in rebellion or insurrection, and have the president declare that's an insurrection. These people have a certain amount of time the president's supposed to outline to lay down their arms and stop, basically disband, quit fighting, whatever. That is historically what was required for an insurrection. I've included in my Substack some authority for that, including a law review article about that exact point. And that was very recent, from 2021, I believe. And so the first issue for the court to deal with is, was this an insurrection? Now, the answer to that is no. Now, the Colorado Supreme Court determined it was an insurrection, and that, we can talk about that. But okay. It's that's really, I'm looking for a word. I want to call it ludicrous. Okay, ludicrous is a good word for it. It's
Fair
just
word.
ridiculous. It's not based on anything outside. It's gross political gamesmanship and nonsense to say that what happened on January 6th was an insurrection. And certainly, that's as a practical matter, certainly within the meaning of federal law. And to back that up, even beyond the law review articles and what the statutory law's been in the past and all of that, is there's a federal criminal statute governing insurrection and rebellion. It's 18 USC 2383, if my memory serves, of
Okay.
all the people charged arising out of the January 6th events. Of all those people, it's over 1,000 people, between 12 and 1,400 people, I believe.
Right.
None, not one, has been charged under the insurrection statute. And the reason for that is the government can't prove there was an insurrection, as that will be required under criminal law. President Trump's not been even accused of it in any of the legal proceedings filed against him. No one's been charged under it. The closest they've gotten are the Oath Keepers. The Oath Keepers were charged under the next statute, which is 18 USC 2384, if my memory serves. That is the seditious conspiracy statute. But that statute is not, they weren't charged with seditious conspiracy to overthrow the government. They were charged with a seditious conspiracy to interrupt government proceedings, the transfer of power. Okay, so they were charged with trying to impede on January 6th, the joint session of Congress from certifying the election, not from overthrowing the government. So even those seditious conspiracy charges for the Oath Keepers did not pertain to insurrection, as that's defined either as a practical matter in the Webster's dictionary or for the purposes of federal law. So this is not an insurrection. Now, the tricky part, when you mentioned about the things you think the Supreme Court, man, they really got to deal with this, that, and the other.
Right.
They've got half a dozen ways to turn this case around. And what they'll typically do is reach a consensus on what the result's going to be and only address the issues they need to address.
Right.
So we very well may wind up with a decision from the Supreme Court that doesn't address a lot of the different reasons why this case should be turned around.
Mm-hmm.
That answers.
No, it does. It does. And for my part, I am in the hope that the Supreme Court is extremely thorough on this question, because I mean, regardless of what someone thinks of Donald Trump, I mean, you can like him, not like him, whatever. I mean, the federal judiciary, or maybe it's better to say certain parts of it, are starting to get into interpretations of law that, if you take them to their logical conclusion, is going to open a whole Pandora's box or boxes that nobody's thinking about right now. And I'm thinking more particularly of the immunity case that got decided before the DC circuit, but we'll get into that one a little bit later. So let me ask you this. For my part, we're going to live stream audio the hearing before the court tomorrow. They don't allow cameras in the courtroom, is per practice of the federal judiciary, which the wisdom of that can be debated, not debated, but that's reality. However, the Supreme Court does allow, because of technology, live streaming the audio. Of course, I mean, I'm going to send you the link for it. If you're able to come in and join us and listen in, that'd be fantastic. But if you can't, I understand that too. You've got to practice, you got to take care of. But when people are listening to the oral arguments tomorrow, when it comes to listening to the questions that the justices are asking, is there anything that a listener should be trying to hear in the questions of the judges? In other words, if you hear this, I mean, again, the questions themselves don't necessarily tell you how a justice is going to rule on this. I understand that, but it gives you at least some glide path of where they're going in their thinking. Is there anything in particular, if someone happens to listen to the audio of these arguments tomorrow morning, what should they be listening for? What words, phrases, questions do you think when you hear it's like, uh-oh, I got an idea where somebody's going with this?
Sure. That's a great question. And let me share first my philosophy or my thought about oral argument.
Okay.
I've argued many, many times, not before, let me full disclosure, I've not argued before the United States Supreme Court, but I've argued in front of the U.S. Fifth Circuit, which is the highest federal court. I've argued before. And I've argued in numerous courts in Louisiana, courts of appeal. I've done, I don't know, probably a couple of hundred arguments altogether on appeals. So I can tell you from my personal experience that rarely does oral argument tip, in my experience, what the court's actually going to do. I can't tell you how many times I went into oral argument and I said, man, that went great. They were asking all the questions that I wanted to hear, and bam, the decision comes out and I wasn't happy. So take all this with a grain of salt. I think that oral argument is important. And the main reason I think it's important is because it lets a lawyer get an idea of if a judge is prepared, or if judges are prepared. It lets the lawyer get an idea of what the judges are focusing on, what the judges are thinking about, because you never know what that's going to be. Occasionally, you brief a case on appeal, and the court seizes on something that nobody briefed very well or nobody thought was an issue. So that's where I find value for oral argument as a lawyer. What does the judge want to ask about? What does the judge want to talk about? And I think that's critical to get an idea of the court's thinking, but it's all supposition.
Sure.
Okay. So if I were listening to the oral argument tomorrow, then I would be listening for questions from the court about, is the presidency an officer of the United States under Article 3 of the 14th Amendment? Mm-hmm. Is the 14th Amendment, Article 3 of the 14th Amendment, self-executing? We need to talk about that.
Okay.
Was this an insurrection? Was there due process violations in the lower court in the development of this record? Things like that are kind of big ticket items that tell you that particular judge is going to be skeptical about what happened and about whether or not this was even a proper thing to do. Okay. Right. And I really, if I had to, people always want a lawyer to put their crystal ball on and, forecast what's going to happen. If I had to bet, I would bet the Supreme Court's going to turn this around. I will fall out of my chair if they don't reverse this. I mean, this Colorado decision is lunacy. But I think the primary reason they're going to reverse it is going to be because Article 3 of the 14th Amendment is not self-executing. And we need to talk about that. It's clearly not self-executing. And the Supreme Court is, in my opinion, going to turn it around for that reason. There's 4, 5, 6 other reasons they could choose to reverse it, but that's the one that's easy.
Okay. Well, we'll get into that argument about self-execution. My name is Brian Trippett. I'm the Front Porch Conservative. I'm joined by author and attorney Daniel R. Street from Louisiana. We're talking about tomorrow morning's oral arguments before the United States Supreme Court of Trump v. Anderson, the Colorado ballot access case. We're on YouTube, we're on Twitter, we're on Rumble. And if you're not following this man on Twitter and his Substack account, do so. I mean, I'm going to give him the chance to plug his places to be on social media at the end, but follow him on Substack, follow him on Twitter. So let's get into the 14th Amendment for a second. We'll get to this question of self-execution. For people who may not have read this up to now, I'm going to read this in its entirety. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid and comfort to the enemies thereof, but Congress may, by a vote of 2/3 of each house, remove such disability. Okay. I think I know where you're going with this, but you use the term, it's the 14th, Clause 3 of the 14th Amendment is not self-executing.
Right.
When you say it's not self-executing, exactly what do you mean?
When the provision was adopted, when it was ratified to become part of the Constitution.
Mm-hmm.
A couple of years later, a couple of the Congress people, congressmen, I don't remember if they were congressmen or senators, who had spearheaded the effort to create and ratify, create, and ratify the 14th Amendment, proposed a law called the Enforcement Act of 1870.
Okay.
At the time, the congressional record, such as it was at that time, reflects that those congressmen said, hey, we passed this provision. Because see, what happened was after the war, the South just sent all the same congressmen back to Washington.
Right.
So these people a lot of them have just fought in the war for the South, and they're back in Congress. And so 14th Amendment got passed. And these congressmen said, look, we passed this constitutional amendment, but there's no way to enforce it. How do we enforce it? So they passed a statute that said, here's what you have to do to have someone declared ineligible under the 14th Amendment. Now Article 5 of the 14th Amendment states that Congress may pass necessary legislation to enforce the 14th Amendment.
There it is.
And this was such a statute. The problem is that statute was repealed in 1948. So since 1948, there's been no statutory mechanism by which this article could be employed. And the reason it was repealed at that time is there was no longer any need for it because everyone who had engaged in insurrection had passed away. So there was no need for it. They repealed it. Now, what that means is, so if Article 3 of the 14th Amendment were self-executing, then any person who's a qualified elector with standing, and when I say elector here, I mean voter. Any voter who had standing could file their own action and have whoever they want declared ineligible for whatever reason under Article 3 of the 14th Amendment. But it's not self-executing. And so what that means is, look at what happened in Colorado. In Colorado, I think it was half a dozen voters in Colorado filed this suit.
Right.
And people don't realize this. President Trump wasn't even a party. The suit was filed against the Secretary of State because that's what was required under Colorado election law. And President Trump had to intervene in it in order to have his side heard. Okay, so if the 14th Amendment, think about this. If it were self-executing, then what the Democrats are trying to do is what would be endorsed. And that would be dozens of challenges in the same state with contrary, inconsistent rulings. You could have different courts rule in different ways. Even in Colorado, you could have 4, 5, 6, 7, 8, 9, 10 challenges in different courts, and each one reaches a different conclusion. And then the state's highest court says, oh, well, here's what we think. You could wind up with a person who could be on the ballot in 25 states and off in the other 25. So it's ludicrous to think that the Article 3 of the 14th Amendment is self-executing. The Colorado Supreme Court ruled it was, but I respectfully submit they're wrong. And the Supreme Court, for that reason, probably more than any other, is going to turn it around.
Oh, I absolutely. I mean, yeah. When I'd come across that same fact about the provisions were repealed in 47 or 48 that enforced Section 3, and it's like, okay, well, if it's not even in effect, then Section 3 is a moot point. Because in order for it to take effect, you have to have congressional action signed off on by the current president of the United States to say, okay, this section of this amendment of the United States Constitution is now enforceable, and here are the terms of enforcement. But if it's not even
how you do it,
here's how you do it. But if that's not even on the books, then yeah, I mean, when Trump's lawyers make their case before the court tomorrow, someone's going to point this out and go, folks, it's in the writ application.
It was in the original writ application. It's in the brief. They've argued it consistently from the very beginning in every single case throughout the country. So, and I think what proves that this article is not self-executing is the chaotic mess that leftist and liberal judges concluding otherwise has led to. It's just litigation all over the place. There's been rulings off the top of my head, Minnesota, New Hampshire, Maine, Iowa, Michigan, Colorado, Florida, Texas. I mean, they're trying this all over the place. And there's no conceivable way that the 14th Amendment allows for that. I mean, it's just insanity to think that it does. Now, that being said, if the Supreme Court concludes otherwise, I mean, it's their call. It's the Supreme Court's call here. This is they wield the judicial power, and if the majority of the Supreme Court says, "Oh yeah, that's fine," then then that'll be that. But I don't expect that to happen.
I don't either, because it's like I said a minute ago, folks on the judicial left don't realize the Pandora's box they're opening here. Let's just assume, for the sake of argument, that the Supreme Court upholds the Colorado Supreme Court in this matter and says, yep, you can remove him. Well, guess what? Texas, Florida, West Virginia, and almost every state in the South is going to bring a case before their court and say, we want Joe Biden stricken from the ballot on the grounds that he's in violation of his oath of office by committing treason because he has not enforced immigration, or what. They're going to come up with something, and they're going to do their dead level best to have Joe Biden removed from the ballot, or anybody else for that matter. And we're going to have an election system that's not governed by the vote of the people, but by, someone wearing a black robe behind a bench. And that's madness. That's not what the founding fathers intended. So yeah, I'm like you. I've got a lot of reasons why I want to see this thing overturned, and it should be in my book. I mean, it makes no sense, none whatsoever.
And one of the issues I really don't expect the court to really address, but it's one of the most troubling aspects of this whole case. I already mentioned that President Trump had to intervene in order to present his side, and he didn't get to present much of his side. Now, think about this. Election challenges are by nature very abbreviated. They're very, very short proceedings. They move for legal matters. They move at a lightning fast pace.
Oh yeah.
Election challenges usually last a few months at the most, and you've got to develop your record, try your case, go through appeals and everything. And it takes very, very short period of time. That's why there's really not enough time in a presidential election to mount an election challenge, because the elections in the 1st of November and the Electoral College is certified in the middle of December, and the joint session of the House and Senate meet on January 6th. I mean, you got 2 months basically in a few days. It's not enough time even for an election challenge. But what happened in Colorado is this election challenge was filed. Those are very, very abbreviated proceedings. And to try to address the fact that they're trying to fit a square peg into a round hole, and a square peg is this case into an election challenge, which is the round hole. The judge, without any real statutory or regulatory or jurisprudential authority, extended the case far longer than the election statute allowed. But even then, it was still very abbreviated. Well, what the court did, now whether or not that's permitted by Colorado law is a question for the Colorado courts. Supreme Court's not going to touch that unless it implicates someone's constitutional right, which it does in this particular instance. It implicates President Trump's due process rights. And the reason for it is because he was very limited in the evidence that could be presented, and the expert testimony that could be presented, and the fact witness testimony that could be presented. And what the district court did was allow, and to a large extent, the January 6th committee's report and evidence. And I use that like in air quotes, evidence.
Oh, yeah.
Because the January 6th committee was political gamesmanship and showmanship. There weren't two sides. There was one side. It was all the anti-Trump side. And it was really the Democrats and a couple of turncoat Republicans, Liz Cheney and Adam Kinzinger. And they cobbled together all of this, really running roughshod over people's rights. And without people having right to representation, without people having the right to cross-examination or anything like that. And they compiled this hearsay within hearsay that this is what somebody said, that somebody said, that somebody else said they said. And they presented that dog and pony show as evidence and came up with a report. And their district court in Colorado allowed that, and the Supreme Court of Colorado permitted it, endorsed it, rubber stamped it, whatever you want to call it. So another thing the Supreme Court of the United States could do, although I don't expect them to get there, would be to just wipe out the whole judgment because it was tainted by illegitimate, incompetent evidence. Now, I don't think they're going to get to that because they don't need to, but it was an unconstitutional kind of fly by the seat of your pants, bogus process that utilized evidence that wasn't evidence. It wasn't competent. Evidence has to be competent and reliable to be admissible. It was inadmissible hogwash to create this record that the Colorado Supreme Court was then able to use to conjure insurrections. And here's another thing that the Supreme Court could do. President Trump, under Article 3 of the 14th Amendment, even if it's self-executing, even if there was an insurrection on January 6th, President Trump didn't engage in it.
Yep.
He didn't engage in it. And to reach a contrary conclusion, and I hate to say this because, the Colorado Supreme Court is just kooky. They get this kooky decision and said, because of what he had said and his exercising his constitutional right to free speech and his constitutional rights to redress or grievances, to challenge elections, they said, all of that adds up to incitement, and they cite the Supreme Court standard, which is Brandenburg versus Ohio, and then turn it totally upside down on its head. I'm telling you, I've been telling people that the Colorado Supreme Court needs to be investigated because I do not believe a majority of any court of actual judges would reach this kind of ludicrous conclusion. That's how horrible it is. And so the other thing the Supreme Court of the United States could do is say, okay, even if there was an insurrection, Donald Trump didn't engage in it.
Yep.
So that's another way the Supreme Court could turn it around.
Yeah, it amazes me because I read a little bit of the dissenting justices on the 4-3 decision from the Colorado Supreme Court, and they're just you can literally see them shaking. You could figuratively see them shaking their heads, writing these opinions, looking over at their four brothers and sisters on the court, going, "Are you guys out of your mind?"
And they're all Democratic
what you're doing. Yeah,
all of them.
Yeah, Democrat appointees.
Yeah. One of the dissenting justices said in 33 years he had never seen anything like it. And I can tell you in 27 years, I've never seen anything like it either. And these are all Democrats, and 3 of them thought this was crazy because it is.
Yeah. Oh, yeah. That's the part that just boggles the mind. I mean, when I was, younger in high school and college, I would, read about some of the cases that the Supreme Court decided in the 60s and early 70s, at the hands of people like Earl Warren and William O. Douglas and others. And I'm sitting there going, y'all were nuts. But then I've now seen it all with this. I mean, this one's going to be like, forget, Bush v. Gore in 2000. This one makes that one look like a Sunday picnic. This is crazy.
Oh, I know.
Now let me ask you this. The oral arguments tomorrow, and granted the court could rule at any point they wish, really, in this term, which ends in June. Do you have, looking into your crystal ball, do you have an idea when they might hand down a ruling on this? Are we looking at March, April?
Yeah, I can only speculate, but let me do that. All right. I'm something of what we would call a court observer. And what that means is I'm always checking to see what writ applications the Supreme Court grants, what cases are those, what are those cases about, how many of them are going to be significant that I might want to read, things like that. Okay. And I've done that my entire career. In fact, even before I was a lawyer, I did it when I was in law school. So I've got 30 years worth of that. This writ application was filed by President Trump's team. I might have the dates off. It's in my Substack, but it was like January 3rd or maybe January 5th.
Yeah, somewhere in that area. Yeah.
48 hours later, the United States Supreme Court granted the writ.
Mm-hmm.
Okay. Now I'm going to tell you, I've never seen the Supreme Court grant a writ in 48 hours. Now, I haven't done a survey all the way back to the beginning of the court, but I'm telling you that does not happen. It certainly doesn't happen very often. Most of the time, it's months before a writ is granted, before you even know if it's granted. And they've got a calendar and a regularly scheduled manner in which they hold that and they consider writs and they post the dates that they're considering different writ applications and all those things. So most people that have a pending writ, they can go to the court and say, oh, okay, they're probably going to consider my writ on whatever day. This one got granted faster than any I've ever witnessed. And then the court set it on a very aggressive briefing schedule. Everybody's briefs were due back in January, set it for oral argument tomorrow. They are going to rule. But the one thing to be gleaned from all of that is that the court's going to rule expeditiously. They're going to get on top of this. They're already on top of it. That's the message they've been sending out. This is of an important national implications, and they're going to resolve it. And I don't think we'll have to wait very long. I mean, maybe 4 weeks. I'd be shocked if the Supreme Court has not ruled by the end of March.
Yeah, I would too. I mean, because there is another consideration, which strictly speaking, the court is not supposed to consider anything outside the law. But let's be honest. Let's just work from the assumption that former President Trump keeps winning in all these primaries around the country. And let's say it gets past Super Tuesday. By that point, theoretically, he will have the requisite number of delegates, or he'll be knocking right on the door of having the requisite number of delegates to be the nominee of the Republican Party for the presidency. If he were to acquire all the delegates or be that close, and then all of a sudden the Supreme Court comes along and pulls the rug right out from under him and everybody who's voted for him, don't tell me that fact is not strolling through the minds of everybody sitting on the bench. Now, should they be thinking about it that way? Well, maybe not. Are they going to? I wouldn't be surprised. It really,
they're going to consider that absolutely, and that's just all about exigency, which means the need to act with urgency. And so the court can consider those things and say, look, we need to rule on this, because the Republican Party's they need another standard bearer if the Supreme Court's going to allow this disqualification nonsense. So that would definitely factor in to the court's intention to move with all deliberate speed, as they like to say, which just means we're going to resolve this really quick. What they don't like to do, and judges just in general don't like to do that, which is to move so quickly and rule so quickly that they're not thoughtful and they're not thorough and they're not comprehensively looking at everything. They don't want to be rushed to the point that it risks, making mistakes and making bad decisions and incomplete. There's an old saying in the practice law that bad facts make bad law.
Yep.
And so the courts of appeal in particular like to ruminate and take their time. So I think, really, frankly, I'd be surprised if the Supreme Court doesn't already know how it's going to rule on this one. I mean, they're not going to admit that, but
no, of course not.
This one's a goner. I'm telling you, look, they're going to turn this around. They're going to flip it around like a flapjack and make the Colorado Supreme Court. I put in my Substack that the Colorado Supreme Court is about to get its comeuppance, and that's exactly what they're going to get.
Yeah, I absolutely agree with you.
Or I am.
Absolutely agree. My name is Brian Trippett. I'm the Front Porch Conservative. We're joined tonight by author and attorney Daniel R. Street. I had some questions from the audience. One of them I think's already been addressed, but for the sake of, making sure I try to be fair to my audience,
Sure.
Gypsy asked the question, not one January 6er has been charged nor prosecuted for insurrection. That's an absolutely valid point. And Daniel had brought this up a little bit earlier that, for all of this hullabaloo related to President Trump, not only have they not charged him with insurrection, they haven't charged any of the J6ers. I'll take it one step further, and I found this out, and I found it to be fascinating. Trump wasn't even charged with inciting a riot on January 6th, which could have been done by the municipality of the District of Columbia. District of Columbia didn't even bother to cite him with it. If you're not even going to cite him for inciting riot, how can you incite him for insurrection is my question. You know.
Well, good question. I have an entire chapter of volume 1 of Fake News Exposed about Trump dedicated to that exact question. Did President Trump incite a riot, or the claim that he incited a riot on January 6th? No, he did not incite a riot. I cited the state, or it's not state, actual District of Columbia criminal provisions about that, and you can read them. And then on top of that, the United States Supreme Court has set forth in, and I mentioned it earlier, in Brandenburg versus Ohio, what the standard is for incitement. And what that means is what's constitutional. So people have First Amendment rights to speak, and that includes the right to be incendiary and inflammatory.
Yep.
But what you can't do is use language that's likely to result in violence and things like that. And the Supreme Court's dealt with that in a number of different cases, because what happens is these incitement statutes are just drafted, and then the question is, okay, when can they actually convict somebody? When does someone's speech go far enough? Because the Supreme Court says, hey, you've got a First Amendment right, and you can't breach that. You can't prosecute somebody for speech that's protected. So really all of the incitement statutes wind up being subject to whatever the standard is that the United States Supreme Court has set. And what happened over the years is most jurisdictions have passed statutes that kind of track the Supreme Court's constitutional First Amendment case law. And so I actually cite the statutes, the relevant statutes, in the chapter of my book dealing with this, and show how President Trump's language, conduct, and the things he did and didn't do on January 6th weren't even close. So to being in violation of either the D.C. district's incitement statutes or crossing the line beyond what the United States Supreme Court has ruled as protected speech. So President Trump didn't incite anybody. He didn't engage in anything on January 6th other than protest. Yeah. Which is constitutionally protected.
Which is his constitutional guaranteed right to do.
That's right. The president has the same rights in that regard.
And one last question on the Colorado Access case, and I don't know if this is going to make any difference for what happens tomorrow, but can you ask Daniel about the ethics complaint against Justice Ketanji Brown Jackson, and if it has any ramifications for tomorrow? Well, I've heard about this ethics complaint that's been filed against her, but I don't know that it's going to prevent her from hearing the case. But I don't know if you've got anything further you want to add on that.
It will not prevent her from participating in the case.
Yeah, okay. So
it's that simple.
All right.
Believe it or not, there's really not a standard of ethics for the United States Supreme Court. So they aren't subject to, you can file all the complaints you want. It doesn't matter.
Sure. Well, let's switch gears just a little bit with the remaining time that we've got. And folks, we're going to limit this to about an hour. And the reason being, unlike a lot of lawyers you see on TV, this guy, he's actually a working lawyer. Okay. So he's got stuff he's got to do. But let's shift gears for a little bit and talk another topic that's sort of Trump related it's working its way up to the Supreme Court now, or it will be shortly. The immunity decision that came down from the 3-judge panel at the D.C. Circuit. I want to show you something, and just this language kind of just blows my mind, and it's this. What I'm going to show you, everybody in the audience, is part of the language that came down in the judge's ruling. Former President Trump moved to dismiss the indictment, and the district court denied his motion. Today, we affirm the denial. For the purpose of this criminal case, former President Trump has become Citizen Trump, with all of the defenses of any other criminal defendant. But any executive immunity that may have protected him while he serves as president no longer protects him against this prosecution. Oh, Daniel, talk about the Pandora's box that's about to be opened if this is taken to its logical conclusion and it's not overturned. I mean, and what I'm about to say next is directed to folks out there who are going to watch this live stream that maybe are on the political or judicial left. You do realize that if this is affirmed at the Supreme Court, that Barack Obama could be prosecuted for the murder of a gentleman by the name of Anwar al-Awlaki, who was drone struck in Yemen along with his son, who was a U.S. citizen, not given due process, not given anything else. So if we're going to take this and say, well, that immunity thing you had while you're in office, that doesn't follow you when you leave. So, whatever happens to you happens. I mean, if you want to go back to Clinton, you want to go back to Carter. I mean, good grief. Every living ex-president could have, or congressman or senator could have this thing. I mean, they could be in court for the rest of their lives. So, I mean, you want to take this one on?
Sure. Look, the United States Congress, House and Senate have immunity. The federal judiciary has immunity.
Yep.
According to these three judges at the D.C. Circuit, the president doesn't. And if he did, it was only while he was president. Boy, they're lucky that's not the rule for judges. I can tell you that. And look, the issues. But there were two basic issues. It's a little more complicated than that, but two overarching issues that are addressed by President Trump's motion to dismiss that was ruled on by the D.C. Circuit 2 days ago now. One is presidential immunity, and the other is the impeachment clause double jeopardy issue.
Right.
Which I actually thought, I think the double jeopardy issue is the big ticket item here, but these are issues of first impression. And what that means is that no court of appeal in the history of this country has ruled on either one of those questions.
Right.
Ever. All right. So that leads us to a couple of things. The first one is that what this panel of judges should have done is just referred this case initially for en banc consideration. En banc means the entire court. So it would be the whole D.C. Circuit. Now, they have to vote. They have to get together and vote on whether or not they want to take a case en banc or not. So it's up to the court about that. They could have said, no, we don't all want to weigh in on this. You three-judge panel, you do it. So here we have this weighty, lofty, substantial decision that's been handed down to say that a president doesn't have immunity for actions taken in his official course of his duties, except while he's actually in office. Okay. And that there's no double jeopardy prohibition. I'll explain that in a minute.
Okay.
In this court, these are lofty questions. These are controversial questions. These are questions that have never been answered before. And what do? They don't even sign the opinion. This is a per curiam. Per curiam is a Latin phrase which means for the court. Per curiams are ordinarily reserved for things that are non-controversial, controversial, that don't take deep consideration by the court. These are kind of simple. Hey, look, here's a per curiam, blah, 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 blah. No particular judge even authors it. Okay. Ordinarily, an opinion has an author. And you'll see, in this case, we had Judge Pan and Judge Henderson, and I forget the other judge, and it would say Pan J for the court, Right. So what they did was handle this in a manner that's flippant, in my opinion.
Yeah.
And beneath the issue and beneath the issues raised and the parties raising them. That's number one. Number two, now look, reasonable minds can differ on the merits here. So there were there were a couple of ways that this court could have ruled against President Trump without beclowning itself like that. Because clearly any immunity that the president had for actions that he takes while being president is going to follow him after his time in office. It's just idiocy to argue otherwise. What they could have said was, well, these weren't core functions. And since it's not a core function, the immunity doesn't follow. But that wasn't good enough for them, So the real question here is, was this politically motivated or not? And to me, there's no question about it. And let me explain why. All right. The government here, the Department of Justice, in this case, the special counsel and the district judge are bound and determined that this case goes to trial before the election. Now, what's the reason for that? What's the only reason for that? Is to influence the election itself. There's no other reason for it. There are people who've been languishing in federal prison or in the D.C. gulag in this country's capital waiting for their trial who've been charged. They've been sitting down there for 2 years and they can't get to them because there's so many cases. And the same judge who's been pushing these cases off for a year and a half or 2 years at a time puts President Trump on the rocket docket. Okay. And the only reason for that is to facilitate the special counsel in the United States Department of Justice and the Biden regime's intent to interfere in the 2024 election. That's my opinion. And the facts clearly bear that out. Now, you say, well, wait a minute now. Why would you say that the DC Circuit's doing the same thing? Here's why. The DC Circuit, when a court of appeal rules in federal court, they issue an order that tells the lower court what the lower court's supposed to do. That's called a mandate. Those are covered by Federal Rule of Appellate Procedure 41. Rule 41 says that a mandate doesn't issue until 7 days after the time for filing for rehearing, if no application for rehearing is filed, or 7 days after the time that the court rules on an application for rehearing or an application for rehearing en banc. Okay? That's what Rule 41 says. This court issued this per curiam and gave President Trump 6 days before the mandate issues. All right. Now, why would they do that? Let me explain the reason for that, or what I believe the reason is. President Trump now has to decide what he's going to do. His legal team has to say, are we going to apply for rehearing, or are we going to try to go straight to the Supreme Court, or are we going to do both at the same time? Okay. This question, like I said, as significant as these questions are, should be ruled on by the entire DC Circuit. Agreed. But the panel, in my opinion, doesn't want that to happen because that's going to slow it down so that the DOJ and the special counsel can't get the case to trial before the election. So if a party applies for a stay to directly the United States Supreme Court, they've got to look at the Supreme Court rules. Supreme Court Rule 23.3 says that a stay is supposed to be applied for in the lower court first before you go to the Supreme Court. And if you don't do that, that the stay will not be entertained, the request for a stay will not be entertained by the United States Supreme Court unless there's extraordinary circumstances. So this circuit court panel has put President Trump in a circumstance where if he applies for a stay to the United States Supreme Court and bypasses a court of appeal, a rehearing process, and doesn't ask for a stay in the court of appeal, they've created a situation where it's the least likely that President Trump gets relief from the Supreme Court. Okay. And then if he applies for a stay or if he applies for rehearing to the DC Circuit Court of Appeal, his 6 days is not even going to get ruled on before the 6 days runs. And the mandate issues back to the lower court so the lower court can put this case back on the rocket docket. Now, the only reason, in my opinion, for any of that to be done is for this panel, was this panel's effort. These three judges, the DC Circuit, it's their effort to facilitate the DOJ and the special counsel and the DOJ and the Biden regime's effort to interfere in the 2024 election. So, yeah, is this political? Is it gamesmanship? Is it beneath the federal judiciary? All of the above. That's my opinion.
Now, you said that he can appeal to both en banc, the full circuit, and to the Supreme Court. But it's one of those deals where the Supreme Court has a rule that says you've got to have this ruled on by the en banc first, and the en banc can say, well, we don't kind of feel like it. So I mean, is he better served, in your opinion, is he better served to appeal to both or go straight to the Supreme Court?
Well, I think if President Trump's legal team were to call me up and say, Street, what do you think? Which is not going to happen.
And by the way, they should, but yeah.
But if they did, what I would do is I would apply for a stay, just to stay in both courts at the same time. I would apply for a stay in, I would do two things. I would apply for a stay of the mandate in the DC Circuit first. Okay. I mean, so at the same time, I would apply for a stay in the Supreme Court and say, hey, to the Supreme Court, they put me in this trick bag trying to create this situation where I can't go through the ordinary appeal process that a party's entitled to go through.
Sure.
So I've asked the DC Circuit for a stay, and I'm asking you for a stay without actually applying for writs. The President Trump's team could do that and apply for writs later. And when I say apply for writs, I meant for a writ of certiorari to the United States Supreme Court. So he could ask for a stay from the Supreme Court without actually filing his writ application yet. His writ application is not due for 90 days.
Okay. All right. So yes, they've put him in a box, but it's a box that can be gotten out of. It's not like I'm damned if I do and damned if I don't. Okay. All right. Well, that's
sure. And I have to tell you, I don't think, I mean, who are these people? Who do these people think they are? They don't get to tell the Supreme Court what the timelines are. So I don't think the Supreme Court's going to appreciate that very much. I certainly wouldn't, and I don't know anybody who would. And I think also the Supreme Court, really any judge who's fair-minded and even-handed and equitable is going to look at this and what is this about? There's no reason for this. And let's keep something else in mind. Look, this is all about things that happened on January 6, 2021 or before. Okay. The special counsel didn't get this indictment until August of 2023. Now, all of a sudden, this case has to be rammed down everyone's throat. And it's illegitimate to even claim that has to be done. This case ordinarily wouldn't even get to trial to 2025 or later. And so, this is just the whole thing. When you hear the Democrats and you hear the left talk about the rule of law, they couldn't care less about the rule of law. And what troubles me the most is to see so many federal judges facilitating this effort. This was wrong. If they thought this case was so great and so important, they shouldn't have sat on it for 2 years and 8 months before they brought it. And there's no reason why this one has to be pushed in front of 300 or 400 people who've been sitting in jail.
Yeah.
I mean, I'm gonna tell you, I get worked up about it. I mean, it's beyond the pale.
I don't blame you. I mean, look, it's like I said, a person can like Donald Trump, not like Donald Trump. But the point is valid. The implications of what are being done here go beyond the question of whether he's guilty of certain actions or not. I mean, if these things judicially are allowed to stand, then we have crossed over a threshold of which they ain't no coming back. We're going to get to the point where somewhere down the line, you're going to have the reverse of what you have now. You're going to have a highly energized Republican Party in control of state legislatures, the federal judiciary, parts of the Congress, and let's say you have a run of Democrat presidents. And if they look back on what's been done now and it's not overturned, then you're going to have the will of the voters in those elections absolutely be cast aside in the name of legal lawfare to determine who's going to be the leadership of our country. And I'm sorry, that's not who we are as a nation, or more to the point, it's not what we should be. So yeah, I don't blame you for getting worked up because, it's not too much to say the right of franchise for the American people is on the line in this. Our decisions that we make through our votes are going to be cast aside if these judicial decisions are allowed to stand. And I'm sorry, that's just not right.
Well, and the other thing to think about, and this is what really made the DC Circuit's decision kind of from my perspective almost laughable, is and look, courts always want to they want to use lofty language and platitudes and sound erudite and all those things. And there's nothing wrong with that, I guess. But let's remember what the DC indictment's about. There's 4 charges levied against President Trump. And all 4, President Trump is charged with crimes through the use of 4 federal statutes that have, and with respect to 2 of the charges, have never been used against anybody in this manner. Let me state that again. Have never been used against anyone, the manner in which they're being used against President Trump. And with respect to the other 2 charges, had never been used against anyone other than J6 defendants. in the manner in which they're being used. Let me elaborate on that real quick, if you don't mind.
Go ahead.
There's two of the charges that are the obstruction of official proceedings charges. That's 18 U.S.C. 1512. Okay. Mm-hmm. That's actually at the United States Supreme Court already. So let's consider this for a minute. All right. 18 U.S.C. 1512 came about back after the Enron scandal. And what happened was some people involved in the Enron scandal were accused of having suppressed evidence, destroyed evidence, tampered with evidence, gotten other people, leaned on other people to do those things. And there were some holes in federal law about that because these were just congressional investigations at the time. So Congress passed a statute that says, hey, if you tamper with evidence, conceal evidence, alter evidence, destroy evidence, or counsel or facilitate or assist anybody in doing that to undermine a congressional investigation or otherwise obstruct an official proceeding. All right. That's what the statute said. So January 6th didn't have anything to do with congressional investigations, but the DOJ didn't have any felonies to charge hardly anybody with. So they conjured up this, oh, wait, they were trying to obstruct the joint session of Congress that was going to certify the election. So that's an official proceeding. We're going to charge all these people with felonies. Okay. One judge out of the DC Circuit said, no, that's a misuse of the statute. Went up to the Court of Appeal, the DC Circuit. Judge Pan, who's on the verdict, on the panel that ruled just the other day against President Trump on the immunity, she just pops up, and supposedly a random allotment. She pops up over and over and over again on all these J6 cases. Been on the court for 18 months, real deep thinker. And she says that it's okay. Now, that's an official proceeding. Sure, that's a proper use of the statute. The United States Supreme Court granted writ on that. I want to say it was in November of last year. Okay. Because one of those defendants have applied for writs, Supreme Court granted writs. Now, 72% of the time, according to a number of studies, if the Supreme Court grants a civil writ, they reverse. So if you're a betting man and there was a line on it, go down and put money on reversing every time they grant a writ, and you're going to be right most of the time. You're going to make a lot of money. Okay, so you start there. But the other thing is, this is a misuse of that statute. It had never been charged in that manner for anybody else. So it's going to get wiped out. If any of these courts were worried about the law, they're worried about justice, they're worried about equity, they wouldn't be in a rush to get President Trump back to district court. What the district judge ought to tell the DOJ, if the case gets back, if she's got any integrity, is tell them, you want to move forward? You're going to move forward without the 18 U.S.C. 1512 charges until the U.S. Supreme Court rules on all that. Yeah. Because otherwise we could have somebody defending the case and go into trial and getting prosecuted on something that the Supreme Court says is not a crime. Okay? So that's number one. Number two, what are the other two charges? Defrauding the United States. They charge him with a statute that's used for tax cheats. Okay. And says he's trying to defraud the United States by challenging the election. And it's asinine. And then what's the other statute? The other statute is the election interference statute that was passed in the 1870s, part of the Ku Klux Klan Acts, that was used against, it literally talks about riding in disguise and trying to intimidate voters. I mean, and here you've got this court, the DC Circuit, writing about this like this is just such a wonderful prosecution. And he's got all these defenses, and it's all a bunch of cockamamie horsepucky that's been literally conjured to create this lawfare and interfere in the election. And I have to listen to the DC Circuit talk about it the way they do. I'm telling you, I think the law is better than that. I expect judges to be better than that.
Absolutely.
And it's very disheartening. It's very disappointing. And then to see the fake news media just fawn over it like it's the most wonderful thing. And you're sitting here watching the rule of law get trampled on by these people, and the media thinks it's great because it's targeting Donald Trump.
Yeah, I mean your point is very valid in that, if this case gets fast tracked and somehow Chattin, they start a trial on a question of obstruction of official proceeding, and then about 2 months later, the Supreme Court, some May or June, says, "Oh yeah, by the way, all those January 6 defendants that have been charged with this, or they've been jailed because of it, yeah, all those get overturned." And then, half of the 4 charges against Trump are just thrown right out the window. And the court, I mean, look, it's like you said, if Shutkin's got any ounce of integrity, she's going to look at Jack Smith and go, "No, we're either you're going to strip out those 2 charges pending this action for the court, or you're going to wait until the court rules on this to find out whether we're even going to go forward with this or not." At least on those 2 points anyway.
And the only time you don't do that is if the criminal defendant that has the right to a speedy trial demands to go to trial.
Exactly. Exactly.
And that would be different. But at every turn, you watch how this breaks down in DC. And when I say DC, I'm talking about the DC District Court and the DC Circuit Court of Appeals. And time after time after time, we see this gamesmanship and this political showmanship masquerading as judicial action. And I'm going to tell you, if it all turned around tomorrow, it would take 3 decades for the federal courts to restore the reliability and restore their reputation with the people of this country. It would take 3 decades, in my opinion, for people to trust the courts again. That's how bad this is. And they don't care. They don't care. You just watch. You let the United States Supreme Court straighten out this bunch of balderdash that a bunch of lefties have created. And the media and the fake news media and Chuck Schumer and that gaggle of clowns will go around and castigate the Supreme Court for doing what they should have had the decency to do to start with.
Oh, absolutely. I don't disagree with you in the slightest. Well, I tell you what, as we talked about before we got started, I know you've got things you've got to do as part of your practice. So we're going to wrap this up. Daniel, where can people find you on social media? What can they best do to support your efforts, to spread the good word about the work you're doing, either as an author or as an attorney? How best can they help you? Where can they find you?
Sure. The easiest way to keep up with what I've got going on is through my website. So my website is danielrstreet.com. So that's danielrstreet.com. There's links to all my books. There's links to my Substack. There's links to my social media. And I'll tell you, this is important for your audience. Right now at my website, you can go to danielrstreet.com and you can get a free digital copy or a free audiobook of my most recent book. Now that book's for sale at Amazon, but you can get the digital version or the Kindle version or the audio version for free. And I just want to get it to as many people as possible. I firmly believe if we educate enough people, if we inform enough people, we give people the tools to see what the truth is, they'll never be fooled by fake news again. And once that happens, they don't have a weapon to wield over us.
Absolutely. Well, this has been fun as always, and I want to thank you for coming back on because, like I say, tomorrow morning is going to be, the Supreme Court only hears 1% of all cases in America, but tomorrow is going to be probably one of the most historic cases that the court will ever hear. And I'll advertise it again, as my good friend Gypsy in chat reminds me to do. Folks, tomorrow morning at 9:45 a.m., I'll be joined by my good buddy Ruben Christopher Haynes. And if Daniel's able to make it, I'm going to give him the link for it too. But we are going to be listening in on the live oral arguments before the Supreme Court of Trump v. Anderson, the Colorado ballot access case. As I said earlier, the court does not allow cameras in the courtroom, but they do allow for live streaming of the audio. So we're going to listen in on it and, spread the word around to your friends. Maybe they've got some time on their hands. They're like, what's all this about? Well, here's your chance to find out the original way. You can go straight to the source on this one. So Daniel, hang around for a second. We'll say some proper goodbyes. Folks, thank you very much for being with us here this evening. This has been a lot of fun. Again, we're on YouTube, we're on Rumble, we're on Twitter. If you're not a subscriber to my channel, please do so, and I would really appreciate it. Thank you, and have a great night, folks. We'll see you at 9:45 a.m. tomorrow morning. Have a good night.